such as the Meketi Bhakti Patel, where they are provided with a motivational speaker, meals, refreshments, and gift for each attendee. This initiative is designed to remove learners from their usual township surroundings. Although this is a personal initiative, the accused actively seeks sponsorship to ensure its success. He has expressed that his intention is to afford the learners experience similar to those of his children, thereby inspiring ambition to exposure to new environments. I'll try to raise it a bit. In reaching out to the elders of the Sasheo community, the accused began by purchasing blankets and slippers for the elderly, later expanding his efforts to delivering food parcels through the EFF. During door-to-door visits in election periods, we observed that many elderly residents lacked proper beds, which led to the launch of an initiative to provide beds, ensuring that no elderly person in these areas sleeps on the floors, a point of personal pride for the accused. Through the EFF-sponsored pilot training program, several community members have qualified as pilots, including the first female pilot from Sasheo, who achieved this milestone in 2023. On his 44th birthday, the accused donated $200,000 to the Tembisa Child Welfare Society. In November 2025, honouring a previous commitment, the accused handed over a disability-friendly house to a wheelchair-bound member of the Sasheo community. Constructed by the EFF, this residence provides dignified and suitable accommodation to an individual who had previously been living in inhumane conditions. Remorse. The accused entered a plea of not guilty to all the charges and, following his conviction, continues to assert his innocence, stating that only a toy firearm was used for discharging the celebratory shots. He has publicly declared his intention to appeal the verdict. Although the accused regards his conviction as wrong, he regrets the incident and the consequent results that people may perceive it as encouragement to handle firearms recklessly. This was not his intent. Criminal behavior and current offense.
We apologize there for that breaking in sound. As you can hear, we are still at the proceedings coming out of the East London Magistrates Court, and this is in the pre-sentencing hearing of the EFF leader Julius Malema. Let's take you back there.
Arrested on 23 October 2019 and made his initial court appearance on 27 November 2019. The trial commenced on 1 March 2022 and concluded with a conviction on 1 October 2025. The aspects of these cases are as follows. Investigations were initiated after a video depicting gunshots fired during the celebration went viral. On 30 July 2018, a spent cartridge was discovered during post-event stadium cleaning. The South African Police Service member responsible for overseeing the EFF celebrations reported receiving no information concerning the discharge or simulation of firearms at the event. The accused was identified as the individual who discharged a .223 Narinka rifle. He possessed the rifle solely for the duration of firing the shots, after which it was handed over to another individual. It appears that the accused received the rifle ready to shoot from someone authorized to possess and handle it, most likely from Tactical Security Services, who provided security services at the celebration event. However, no individual was convicted of supply or transferring the firearm to the accused, and the rifle that was shown in court was returned to Tactical Security Services before judgment was delivered in this trial. Following the event, there were no reported injuries or damages to property. All equipment used at the venue was inspected and no damage was recorded. Seriousness of the offences. In assessing the seriousness of the offences, it is necessary to evaluate both the level of actual and potential harm caused by the acts in question, as well as the degree of culpability attributable to the offender. The Firearms Control Act 60 of 2000 prescribes sentences for such offences, including the option of a fine or imprisonment for maximum periods ranging 5 years up to 15 years. For a first-time offender convicted of possession of an automatic or semi-automatic firearm, the Criminal Law Amendment Act 105 of 1997 stipulates a minimum sentence of 15 years. As noted by Detroit 2020, page 13, the court in S versus Mulahi observed that the enactment of minimum sentence legislation for the illegal possession of automatic or semi-automatic firearms was a response to the frequent use of such weapons in the commission of violent crimes. A central objective of the Firearms Control Act 60 of 2000 is to curb the proliferation of illegally possessed firearms and to prevent crimes involving firearms by removing such weapons from circulation. This purpose significantly heightens the seriousness of firearm-related offences. However, in the present matter, the considerations mentioned above do not apply and certain mitigating circumstances are evident. The accused obtained the firearm from an individual, most likely affiliated with Tactical Security Services, who was authorized to possess and managed a licensed firearm. He did so solely for the purpose of discharging celebratory shots at the event. There is no indication that the firearm was acquired illegally for a prolonged period or with any intent to facilitate further criminal activity. It appears that the firearm was returned to its lawful custodian promptly thereafter. The accused's possession of the firearm and a single round of ammunition was limited exclusively to the period during which the celebratory shots were fired, which, while not precisely timed, is estimated to have lasted less than 1 minute. Additionally, the Firearms Control Act seeks to uphold the constitutional rights to life and bodily integrity and to penalize the negligent or unlawful use of firearms. In this context, the following considerations are relevant. There is no evidence that the accused intended to cause harm. Nonetheless, the court found that he discharged the firearm in a public space without implementing the necessary precautions to ensure the safety of people and property. By neglecting to take such precautions, it has been said that the accused acted recklessly, thereby endangering the lives of celebrating members, bystanders, and residents of neighboring areas, and risking property damage. Such conduct could have resulted in loss of life. It has also been said that the careless and reckless discharge of firearms in a public setting conveys an inappropriate message about gun safety and responsible firearm use, particularly when a prominent leader exhibits such conduct. The actions of individuals in positions of influence are likely to be emulated by their supporters, thereby warranting a more severe assessment of their behavior. It has already been noted that the accused regrets the incident and the consequent perceptions it might have created. However, there was no evidence indicating any harm to a person or damage to any property. Planning. The firing of celebratory gunshots was deliberately planned as a distinctive element of the event, reflecting the established tradition of incorporating unique features into each celebration. For instance, during the 10th anniversary, the accused approached a section of the stage that elevated into the air while red and gold confetti was released from cannons. Available information does not suggest that the planning of this activity was undertaken with the intention to commit an offence, endanger lives, or cause damage to property. Interest of society. The interest of society is upheld by imposing a sentence that delivers the greatest benefit or minimizes potential harm. In considering an appropriate sentence, it is important to consider society's economic stake in the cost of the criminal justice system, ensuring that any punitive measure is justified by the tangible advantages it provides. The objectives of punishment are rooted in the protection and advancement of societal interest, encompassing prevention, deterrence, rehabilitation, and retribution. Prevention. As noted by Blanche, the incapacitation of an offender becomes especially significant when the individual poses a danger to society and when imprisonment is the only means by which the public can be safeguarded. In this instance, prevention is not regarded as a primary objective. The accused is a first-time offender, did not actively intend to cause harm, and no person was injured nor property damaged because of the offence. Furthermore, despite the lapse of many years, no subsequent offences have been committed. Deterrence. There are two recognised forms of deterrence. General deterrence, which aims to dissuade members of the public from engaging in criminal conduct, and individual deterrence, which seeks to prevent the accused from reoffending. The accused's personality profile suggests that his actions are driven by a desire to behave correctly and ethically. He has emphasized his position as the leader of the fourth largest political party, highlighting the considerable influence he holds over young people. He recognizes that he cannot credibly encourage others to respect the law if he himself is found guilty of a criminal offense. This awareness is expected to exert a strong individual deterrent effect. Furthermore, having been tried and convicted is also humiliating to the accused, serving further as an individual deterrent. Justice Edwin Cameron, a retired judge and current inspecting judge of correctional services, wrote in an article dated 9 August 2021 that the most effective deterrent to crime is the certainty of consequences. Certainty of investigation, detection, arrest, arraignment, prosecution, and ultimately punishment. This principle was also affirmed by the highest courts, as reflected in the case of S versus Makonyane, which stated that the greatest deterrent to crime is the likelihood that offenders will be apprehended, convicted, and punished. It is the certainty of punishment rather than the severity of the sentence that is likely to have the greatest deterrent impact. Rehabilitation. Rehabilitation seeks to assist the offender in becoming a law-abiding member of society. While the accused maintains his innocence, he acknowledges the inherent risks of discharging a firearm in a public setting and regrets that the perception could be created that it is acceptable to recklessly discharge a firearm. He is a first-time offender and has not committed any further offences over the past 7 years. These factors, together with the individual deterrence previously discussed, suggest that rehabilitation is not a primary consideration in this case. Retribution. De Blanche asserts that retribution serves as the underlying principle of all sentencing, forming an integral part of the concept that every sentence must be proportionate and appropriate. This determination should be made objectively, considering the Zen trial and the degree of culpability attributable to the offender. Cameron, Gore, and Surajpal indicate that justice for victims requires accountability for blameworthy conduct, but not necessarily through the prison system. The question is asked whether we would not be better served by expanding our idea of what constitutes justice to include ideas of restitution and reparation. The above-mentioned authors further indicate that even if embracing retributive and vengeful instincts is warranted, there is a danger of disproportionate and excessive forms of punishment. In line with these sentiments, qualitative research conducted among legal practitioners has revealed that the justice system currently places excessive emphasis on retribution and relies heavily on imprisonment, often to the detriment of restorative justice alternatives. Sentence options. The determination of potential sentencing options is shaped by statutory requirements governing sentence severity, as previously discussed in relation to the seriousness of the offence, and which indicates the option of a fine and imprisonment. In this context, sentencing objectives remain the primary consideration alongside the accused's personal circumstances, especially when evaluating the appropriateness of a custodial sentence. While recognizing that each offender and offence represent unique factors, reference to certain sentences commonly imposed in comparable cases offers valuable guidance in identifying suitable sentencing options. Sentencing trends. In his analysis of sentencing practices pertaining to the unlawful possession of semi-automatic firearms, the tool examines sentencing trends in the context of the Criminal Law Amendment Act 1997 and the Firearms Control Act 60 of 2000. The findings highlighted several key aspects. The implementation of minimum sentencing legislation for the illegal possession of automatic or semi-automatic firearms is linked to the prevalence of such firearms being used in the commission of violent crimes. In considering the application of minimum sentences, the specific circumstances under which the possession occurred, as well as the intended purposes of possession of the firearm, are critical in determining whether substantial and compelling circumstances exist to justify a deviation from the minimum sentence. Courts are more inclined to impose the prescribed minimum sentence in instances where the accused is also found guilty of other serious offences such as murder and robbery. Considering the facts of this matter, it falls outside the above-mentioned considerations regarding a decision to impose a minimum sentence. Furthermore, in line with the Machongo matter, bearing in mind that no evidence was obtained which suggests that the accused was forewarned about the likelihood of the application of a minimum sentence, it is respectfully submitted that a minimum sentence is not applicable. Despite warnings in the press with regards to dangers of celebratory gunfire, no case law on conviction or sentencing for discharging a firearm for celebratory purposes could be found, indicating that charges are not generally instituted in this regard. The accused may be the first person charged with discharging a firearm for celebratory purposes. Annexure 2 of this report referenced judicial decisions concerning the discharge of a firearm in public or incidents of reckless endangerment to persons or property. Consistent with the sentencing provisions outlined in the Firearms Control Act 60 of 2000, prevailing judicial trends indicate that sanctions consist of a fine and/or a wholly suspended term of imprisonment. However, where the discharge of a firearm resulted in injury to another individual, courts have deemed direct imprisonment to be an appropriate sentence. In the matter referred to in South African Human Rights Commission and another versus Malema and another, the court deemed the fine to be an appropriate sanction, notwithstanding the fact that the firearm was discharged in a conflict situation. Conversely, in the Oscar Pistorius case, where the firearm was discharged not only in a public setting but also within a confined space, thereby heightening the risk of harm to individuals and property, the court found that a wholly suspended term of imprisonment was justified. Imprisonment, whilst the state's view on an appropriate sentence is uncertain, it is necessary to address relevant information relating to imprisonment. Imprisonment is widely recognized as the harshest form of punishment, generally justified by the objectives of retribution and deterrence. According to Cameron et al., except for in the most extreme cases, imprisonment remains a terrible thing. It has profound and far-reaching consequences for families, which extend across personal, social, financial, emotional, psychological, and physical domains. Since the family is often considered the foundation of society, any harm inflicted on it may worsen societal problems and contribute to elevated crime rates. In this light, Cameron et al. Advocate for comprehensive reforms within the criminal justice system, particularly the prison system, to enhance public safety and foster a healthier society for all. With regard to the accused's personal circumstances, several key factors warrant consideration. The accused is the main financial provider for his family. Therefore, a custodial sentence would directly threaten the family's financial security. He is the father of 3 children aged 9, 9, and 7, and husband to his wife. As an actively involved parent with a strong family orientation, his absence would disrupt his children's and wife's emotional, social, and psychological well-being. It is important to highlight that accused receive a custodial sentence in 12 months without the option of a fine. He will be rendered ineligible to serve as a member of the National Assembly. This disqualification will persist for 5 years following the completion of the sentence, thereby restricting his ability to represent his constituency during this period. The accused enjoys notable support within the South African society, with many subscribing to his philosophy and expressing confidence in his leadership within key institutions such as the National Assembly. His removal from office would inevitably create a void for the communities he represents, potentially diminishing their voices and the hopes he has consistently championed on their behalf. Finally, the accused's active involvement in community initiatives would be interrupted, placing the continuity and sustainability of ongoing projects at risk to the detriment of the community. Considering the facts of this case and the personal circumstances of the accused, it is necessary to carefully assess whether any form of imprisonment would constitute the most appropriate or just outcome. Evaluation. The purpose of the evaluation is to assess the risk of recidivism and to identify key factors that may inform and guide sentencing decisions. The following are considered protective factors which substantially reduce the risk of reoffending. Strong social support. The accused learned the importance of family from a young age, continued to maintain close family relations, and relies on the support of his family when necessary. Resilience, coping abilities and thinking skills evidenced through a progressive career trajectory despite challenging childhood circumstances. Low risk in terms of criminal history. The accused, the 44-year-old first-time offender, committed the offence at the age of 37 and fully cooperated with court for 5 years. He has not reoffended since. Pro-social behaviour as indicated by his active community involvement. Although not part of the sentence, any form of pain or discomfort an offender suffers as a result of committing a crime can be seen as punishment and moral retribution. The following is noted in this regard. The lapse of more than 7 years between the commission of the offence and conviction is regarded as a mitigating factor. Beyond the financial burden, the court in S versus Michelle acknowledged the considerable mental anguish experienced by appellants who endured prolonged uncertainty regarding their future, recognizing this as a relevant consideration, and humiliation and public shame, having been morally declared of having done something wrong. Although the accused maintains his innocence, which is often viewed as a risk factor, his recognition that a criminal conviction would undermine his ability to credibly promote respect for the law notably diminishes the likelihood of reoffending. As a revolutionary, the accused frequently challenges established conventions, while his readiness to address perceived injustice may continue to invite controversy and potential legal scrutiny. These actions alone do not necessarily heighten the risk of him reoffending unless future criminalizes specific behaviors such as hate speech. Conclusion. Given that all 5 charges stem from a single incident and video footage shows that the accused did not load the firearm, it is recommended that the charges be considered collectively for sentencing purposes. After a thorough assessment of the accused's personal circumstances, the seriousness of the offences, societal interests, and relevant legislation and case law, the following sentencing proposal is made. Impose a fine that reflects the gravity of the offences, with the fine suspended to encourage continued lawful behaviour. Restrict the accused from obtaining a firearm licence for a specific period as an ongoing deterrent. Require the accused to make a monetary donation as restitution to Gun-Free South Africa, an NGO focused on reducing gun violence in South Africa. It is acknowledged and accepted that the duty to impose an appropriate sentence rests with the Honourable Court.
That is your report. Next to your report, you've also detailed your resources that you utilize in compilation of the report, and who you actually consulted. That's at page 36, is that correct?
That is correct, Your Worship.
And then further, the cases that you cited in the report, the legislation and documents that you have brought to.
That is correct.
You also, as I understand, you report have brought to the Worship's judgment on the matter.
That is correct.
And you've also done, as an annexure 1, the background of your background as an investigating social worker.
That is correct, Your Worship.
Page 39. Can you take us through those qualifications, please, Madam Judge?